We also offer media training workshops, live streaming, documentary production, and events management. Get in touch with us today on the following numbers: +263 867 711 0290 or 0718 100 235. Don't forget to subscribe to our social media platforms. Like our Facebook page, Center for Innovation and Technology. Follow us on Twitter @SiteZW. And you can also check out our website, www.site.org.zw.
Welcome to Know Your Right. My name is Brighton Ncube. Today on the show, I'm joined by Robi, a fourth-year student at Zimbabwe University studying law. Today on the show, we're going to discuss the issue of child rights and child marriages. Brian, welcome to the show.
Thank you, Brighton.
Right, we're talking of children's rights. What are we talking about exactly?
Okay, first we need to define what, or have an understanding or comprehension of what is meant by a child, right? And then with their rights, these are legal entitlements. So as a child, you have this kind of legal entitlement. The questions that rises there is whether children should enjoy rights that are different from the adults, their counterparts. Whether their rights should be more limited or be more sui generis compared to those of the adults. So that's what the children's rights discourse is all about.
But now, if you're looking at the Section 81, rights of children, every child, that is to say, every boy and a girl under the age of 18,
yes,
has the right to equal treatment before the law, including the right to be heard.
Yes.
Let's talk about the right to be heard.
Okay, the right to be heard, right? What I'm simply saying is that let me refer you to that same clause, rights of children's clause, right? Subsection 2 of your document. A child's best interests are paramount in every matter concerning a child, right? I'm answering your question in that regard to say, now, that provision simply says, like every law provision would do, a child's best interests are paramount in every matter concerning a child. But the question rises, what is in the best interest of the child? What is it that we call this is, the best for the child? Now, in reaching that conclusion, you now take many factors, consider many factors, including the child's voice. You can't really determine what is in the best interest of the child without really taking into account what the child thinks or views. You take that into consideration. It's not an overriding factor, but you take it into consideration before you reach a decision that I'm going to do this because this is what is in your best interest. As part of it, you take into account the child's voice.
Let me bring that bit of, we are in a family setup.
Yes.
There's a father and a mother. There's a nuclear family kind of. Child is 18 years now. So the father will say, as long as you're under my roof, you still hear from me. I still make decisions in this house.
Okay.
But now the aspect of the right to be heard in terms of what?
Okay, first of all, to correct you on that one. Once they are 18, whether they are in their father's roof or way, they are no longer children. Right. A child is someone, according to the Children's Act, someone who is, the Children's Act really says someone who is 16 years and below. But it's an act that came before the Constitution, that there is still a room to align our laws to the Constitution, because the Constitution is the supreme law. However, according to the Constitution and according to the sort of case, the one that outlawed child marriages, a child is someone who is less than 18. In conformity with the international laws that Zimbabwe subscribed to. That Zimbabwe is a part of, like, the Convention on the Rights of the Child, etc. So we are talking someone who is less than 18, right? And one other thing is that the law, these rights apply across the board, whether public or private. To understand that the sub-provision, subsection 2 that I referred to, it says in every matter concerning what? Concerning the child. Child's best interest must be what? Paramount. So, in every matter, whether it's at school, public, right? Whether it's at home, whether it's at church, whatever, as long as the child is involved, then the best interest must be considered. So, to answer a question you asked about a family setup, right? When you're simply saying a child has a right to, it's in conformity with the right to participation. It's a principle under international children's rights discourse. So, you're simply saying, as a parent, as a father, when you're deciding, for instance, which school to take your child to, you don't just make those arbitrary decisions. To say, I've decided to take you to this school. It's important that you ask them, which school do you want to go to? Then they tell you, you hear them. Although that won't really say, like, because they say they want to go to Dominican Coventry, you take them, they automatically know. But when making a decision on which school to take them to, you also consider your financial capacity, their voice where they want to go to, and then there are other issues, whether that school is, you think that school is good, blah, 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 and all. But at the end of the day, the right to be heard is enough. Like you're simply saying, they should have a voice.
But now, if you bring the issue of corporal punishment in schools, we have seen students refusing to be beaten, to be punished at schools. It was passed by the government. Must not be punished at schools.
Okay. Many jurists, I'll start from a general to specific, or from general to particular. You look at it, Brighton, many jurisdictions. Why? Because of that same order. I told you that there has been an advent of human rights discourse, which is, of course, under UN, right? It started in 1948, the Universal Declaration of Human Rights and stuff. So those people, human rights lawyers and human rights activists, in upholding their, ways and activities to say we need to promote human rights in whatever we do, they came to a point that corporal punishment should be illegalized. For what reasons? They said many reasons, that it violates on certain aspects of right, the right to freedom of torture, the right not to be subject to degrading punishment, because corporal punishment can be really degrading, right? So, coming to Zimbabwe now, many jurisdictions, of course, have complied with that provision, long complied with that provision. Coming to Zimbabwe, it's again a controversial issue. Like I said, with issues of law, it's never a straightforward issue. There are always two sides to a coin, and both edges of the sword can cut. There are people saying, no, corporal punishment is not acceptable in Africa. We have our values, blah, 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 right? There are people saying, no, it has to be abolished for 1, 2, 3 reasons. So what happened is the issue first came to light in our jurisdictions. I think 2016, if I'm not mistaken, when the High Court abolished it, right? To say someone brought a case and then argued their case, say no, corporal punishment should be outlawed for 1, 2, 3 reasons, right? And then because the High Court was persuaded, it ruled that corporal punishment is illegal, right? And then it did outlaw that one. However, because it's a constitutional issue, this is how the hierarchy and the system of our courts works. Because it was a constitutional issue, the High Court cannot just outlaw it. Once it outlaws it, it should be confirmed by the Constitutional Court, right? So there are 2 decisions under which the High Court did outlaw that one. But it was confirmed finally recently by, I think you saw the newspapers, that the Constitutional Court confirms the outlawing of corporal punishment. What it means is it's now illegal. To give you the reasons, one of the reasons is that it violates corporal punishment on its own is a direct violation of what? Of Section 81, right? Because Section 81, this is, if you can read it for me, it says every child is what?
Section 81, section 1.
Oh, yes, what?
Every child, that is to say, every boy and a girl under the age of 18 years has the right to equal treatment before the law, including the right to be heard.
Right. So let's go to equal treatment before the law. Look at now how they want. This is a constitution. And then we have, I'll take you to subsection 2, if you come with me, at the beginning bit, right? We have this provision in the constitution, 81, right? Then subsection 2, which is what we call the supremacy clause, right? Simple reads, this constitution is the supreme law of Zimbabwe, and I'm saying it. And any law or practice, custom or conduct inconsistent with it is invalid to the extent of what? Inconsistent. So, corporal punishment is a practice. A practice which is what? Inconsistent with Section 81, for instance, of the Constitution. Why? Because this provision provides for equal treatment of child. But if you look at how corporal punishment is carried out or was being carried out at schools, it's kind of like unfair in the sense that, for instance, boys could be beaten on their buttocks. That's a good example. But girls are exempted. So what we already have, there's a practice whereby boys and girls are treated differently. That practice now, according to the law, is something that is inconsistent with Section 81, because Section 81 says every boy and a girl, right, must be treated equally before the law. So that's one of the reasons why corporal punishment had to be outlawed. And then it infringes now on the issue of right to not be subject to degrading punishment, Section 53 of the Constitution that we discussed earlier, right? So it's a degrading punishment in some way. Why? Because there is the argument that should we treat children as less humans? Should we treat children as extensions? Because that's what corporal punishment will do. Where we say, as long as you are my child, right? You are my extension. I can do whatever I want to you, beat you if I want to, and then, you know. But can you treat an adult person the same way you would treat a child? Those are the issues. To say, in other words, practices like corporal punishment have the effect of reducing children to half humans, not full humans. Yet, under the law, they have the full capacity. They should be treated as human because they are humans who exist on their own. Besides the issues of independence, financial independence, blah, blah, blah. But they are human beings who have rights that should, you know, equally upheld, the rights to human dignity and all. So that was the rationale, and it has been outlawed, but though we have challenges in our judicial system in that we do make pronouncements, but those pronouncements really are not effective until a law comes in to make it effective. Because right now, even if I beat up my child, despite the Constitutional Court having said it's illegal, what are you gonna do? Because there is no way, there is no measure of, you know, or no sanction.
But let's talk about now society losing its moral fabric. People are saying what the kids now, children now, are because of these rights. They now know their right. They want to be heard as according to the Constitution. Now, how do we now discipline our children? How do we now talk to them? How do we now correct them without infringing on or violating their rights?
I believe in other ways or measures of reprimanding children other than resorting to violence, because corporal punishment is violence in some sense. What we're simply saying is we are teaching your child that violence is the way to go. Violence is the way of, you know, solving issues. So don't be surprised when your boy child uses violence to, you know, discipline either the wife or what, you know. because that's what they've been, taught, that no, violence is the way to what is the answer. In a way, I know that it's not African. In Africa, and of course, there are even biblical justifications to it, spare the rod and spoil the child. But really, the issues of human rights are against that, right? Normally, these two infringements, because human rights are a Western concept, right? Just as our education system is a Western concept. African values are losing. Why? Because most of African values are really more like derogatory. They are really outdated and primitive. Most of them. They are unique African customs, but you can't talk about issues like virginity testing. For instance, it's an African practice that our forefathers used to take pleasure in, and foremothers, like grandmothers, used to take pleasure in. It was a normal practice to say, we need to go through this for 1, 2, 3. But you can't talk at this day and age, you can't talk about subjecting someone to virginity testing. It's totally, not in line with the human rights issues. It's same with the corporal punishment. It was a unique African value, right? But it's getting outdated. Where someone saying there can be better means of resolving children. For instance, that issue of involving the child to be heard, right? Long ago, I don't think you could even say, wait, they will decide whether they tell you are going to this university to study this. You don't have a choice than to go there because they think, your parents think that's best for you. But you can't know what's best for the child without involving them. You need to hear them, what they want, their passion, then you involve them, right? So dialogue with children, it's important. Yeah. It's possible to solve issues, without resorting to violence.
Earlier, when I was talking to someone, the issue of Vuzus in Bulawayo, whereby the last Saturday of ZITF with their children there around Vista, Situ, HNS, many children, when you see them, they're young, they appear young, but someone said to me, they're over 18, most of them. Saturday, they were removing the ideas, going into bars, into clubs, because they're over 18. Now, how do we, but say, this one is a child, is under 18, by saying, looking at them, how to discipline those children now? Do you raise the age limit to 21? What do we do?
You really cannot tell how old someone is, maybe by just me looking at them. And then with the issue of raising the age limit, I'm not sure about that one, but I don't think it's practical.
No, I'm writing on the issue of right to be heard. Because some of them, they look young, but they're over 18, but they're making the mistakes. That we see this one is making a mistake. The moral, the fabric, does not degrading.
Let me point out something. When it comes to issues of law like this one, we are saying moral content, what we call bonus morals in Latin, right? The moral content of the society, yes, comes into play. But law is law. Law is one thing, right? To understand that moral issues really do not usually come into play. I don't know. We believe that every parent has that kind of duty to say they must restrain their child in one way or the another. Of course, not to resorting to violence, because even if you to resort to violence to try and restrain those kids, it won't work. You need to find other alternatives. Maybe I'm commenting maybe from a social perspective, not from a legal point of view, because from a legal point of view, I don't think there is an answer to that one, unless or until they commit a crime. You understand? The law cannot provide how someone who's over 18 should behave, because at the end of the day, we are simply saying you're now an adult. You are operating within your rights. If they feel like going to those parties is what is right, then the law really cannot come in until they consider do something that is what unlawful. That's where the law can come. But as a society, these are things that I think there are organizations, I don't know, or community leaders, organizations like residents associations and council. Those are the issues that they need now to sit down and try to find measures of restraining their children as a societal kind of mechanism, not as a legal machinery. Why? Because really within the legal framework, they'll be simply saying, we know our rights. And for sure, they have those rights at the end of the day. Yeah. So, I don't know what could be done, but the society needs to come together.
Now, let's look at the events of January 14 in Zimbabwe, shut down Zimbabwe Stairway. We saw minors, children, being arrested. Some said they've looted, some being arrested, and some being detained for longer periods in jail. So now let's look at this clause that say every child has a right to not to be detained, except as a measure of last resort.
Yes.
And if detained, to be detained for the shortest appropriate period.
Yes.
But now we've saw those children being detained for longer periods. Some of them being detained at Kami prison. How do you respond to those issues whereby the children's rights are being violated by the government?
Whenever issues of human rights violations, whether the rights are of a child, whether the rights are of an adult, come into play, you enforce them by going to court, challenging them at court, right? But I will mention now, for the benefit of our discussion, that we have situations whereby we have children's criminal justice. It's totally different. The way children should be treated in terms of law is different from the way the children from the way the adults are treated under criminal justice. So our criminal justice for children is user-friendly in other ways. To understand that whether it's the accused person or it's the victim, whether the child is accused of a crime, they shouldn't be, incarceration is that provision simply say there are other ways that they should be dealt with, unless when the push comes to shove, then we can resort to detaining them. And once we're detaining them, we're doing so for a short period of time. They shouldn't be kept in the cells for a long time. 1, 2, they shouldn't be mixed with the mature inmates.
Yeah.
Those are kind of the issues. Even when you discover that, even when they go to court, it's a different situation altogether. It's not the usual environment that you find at court, because there is a child involved. Even the way of questioning a child, even the way of examining a child is totally different. So really, even when, let's say, child victims, they are you are not made to meet your, let's say it's a rape case, for instance, and you don't meet the perpetrator. There is a way of doing it. You probably examined in a different setup altogether. So we have our own system, including the victim-friendly units at the police and all. Those are they now to uphold that kind of provision. So no, children should be dealt with in a very sensitive manner.
Let's talk about the issue of child marriages as well as the child consent, the age of consent in Zimbabwe. There's been a debate about the age of consent from 16 to 18, or to be reduced to 12. Some are saying to reduce to 12 years. But now, someone with 12 years to get into marriage, let's talk about child marriages. How do you relate to those issues of child marriages in Zimbabwe? And also how tradition is playing a role in terms of those child marriages?
Maybe just to commence with the background, right? You'll discover that before this constitution, we have our Marriages Act, chapter 5.11, right? The Marriages Act is a law that came into place, I don't know, a long time ago, around 90s or 80s. I'm not really sure of the position, but it came into operation a long time. And it has been operating, right? And it's still operational. Then we have our constitution coming into play, right? So Section 22 of that act was saying every girl who has attained the age of 16 can enter into a marriage. Every boy who has attained the age of 18 can enter into a marriage. Right? So, in 2016, when our current Chief Justice was then the Deputy Chief Justice Malala presided over the matter, a case was brought into the Constitutional Court to say, by Mtsuru and the other applicant, right, to challenge that provision that I just referred to, right. The lawyer argued the matter was tender-fit in that case. So their argument was this: if you look at Section 78, marriage rights there, right, it says what?
Every person who has attained the age of 18 has the right to found a family.
Every person who has attained the age of 18 has a right to found a family. It's not a clear provision, it's a controversial provision, but it's just like that, right? Then we have remember, what does remember our Section 2? Mm-hmm. The Constitution is the supreme law of the country. Any law that is against it is inconsistent, right? So we have now our Marriages Act saying what? I think the inconsistency that was being challenged. Mm-hmm. We had our Marriages Act saying a girl 16, a boy 18. Mm-hmm. Already there you have some kind of a violation, because the argument, the applicants, they were arguing that every person, this provision simply means in short that when you are 18, less than 18, you shouldn't be married. Mm-hmm. The legal age of marriage in Zimbabwe is 18. Right. Of course, the guys working with the ministries and all the people say, no, that provision doesn't mean that. It says right to found a family. It doesn't talk about marriage. But when you take a purposive approach to this provision, the court concluded that it does mean that's because to found a family means to get married. Then so you can't be arguing that it doesn't mean getting married and all. So the other problem. The other challenge, apart from this one, right, was they were saying Section 22 also presents some kind of a discrimination, which violates Section 81. Because our Section 81 says what? Every boy and girl must be treated equal. Yeah. Right? Then you have a situation whereby a law says a girl 16 and a boy 18. Already, we are simply treating them differently. Yeah. So that's what they were challenging. And the court now, having been persuaded by whatever arguments were made, they concluded that indeed the legal age of marriage should be 18. They struck off that provision, invalidating that this provision in the Marriages Act, Section 22, is no longer what? Is invalid because it is inconsistent with the Constitution. Now, we celebrated, and we are still celebrating, as the children's rights lawyers and activists say, that was a good move in reaching our jurisdiction. But a challenge now comes, a looming challenge comes, that something needs to be done. Like I said earlier on with the corporal punishment, you make a pronouncement that corporal punishment is illegal, but you don't make a law. There is no law, a follow-up law to make it effective. Then at the end of the day, we have problems. Because even if I do it, what are you going to do? On what basis are you going to punish me? There is no sanction, there is no punishment to say, if you do this, if you beat a child, you can be arrested, or this can happen to you. There is no threat of sanction. Same with child marriages. It's still a empty pronouncement because it was abolished, yes, but there is no law as yet detailing what could happen or what should happen to people who marry children, to people who marry children who are less than 18. You see? And then the other looming challenge is that which you raised of consent, to say the age of consent remains 16. Mm-hmm. I cannot even think about reducing it to 12. That's absurdity and insanity. But other people think it's possible, but no, we can't even go there. Let's look at it at 16. My opinion is that the same pronouncement made to 18, it should also be moved to 18. Of course, there are arguments that girls mature fast and all, but it should be moved to 18 to make this law effective, in the sense that we are creating a lacuna if we leave it like that. What are we saying? We'll be simply saying, well, we have our age of consent as 16 and our age of marriage as 18. Then what it means, we are simply saying, you know what, girl child, you can consent to sex. You can consent to having sexual intercourse, but you can't get married at that point in time. So what it means is, if they get pregnant at 16, then I'm pregnant, but they can't get married to whoever impregnated them. Because some say, the law is against me marrying you. But the law is not against me impregnating you. I think that kind of lacuna. So I don't know how it should be done, but there is a need to reconcile.
Also, in terms of, to add on what we're saying, the issue of gay marriages, our constitution says persons of the same sex are prohibited from marrying each other. Someone said to me they can date each other, they can be in a relationship with each other, but it's story of another day.
Actually, in that regard, that was my first discovery when I go to the law school. Before law school, I always thought Zimbabwe is antique. I remember by then the president was still His Excellency Robert Ncube, but was known for being against gays, and so I always thought we are a state against gays, until I go to the law school, and then I discovered that there was no law prohibiting people from dating each other. The only law that is there is Section 783, which says that persons of same sex are prohibited from marrying each other. What I mean is they can't marry each other,
but
they can date. Once they're dating, they haven't violated the law. But at the moment they decide now we want to marry each other, that's why they say, now you're going, you're now violating.
But now, how do we put those laws in line to tally and be on the same page? This law, Section 78, Part 3 says person of the same sex marriages. But now, how do we put it into context and say even also dating is not allowed, or is it allowed? How do we put those things in context?
Now,
because people out there don't understand these issues. People assume gays are not allowed in Zimbabwe by saying this thing on the constitution, but they don't know.
Those are major weaknesses that our legislators need to take into part. When it comes to males, at least we can maybe say it's better, because we have the Criminal Law Codification and Reform Act, Chapter 9.23, right, which points out that there is sodomy there as a criminal offense. It makes sodomy a crime. And maybe we can say, when it comes to men, it's better because we have sodomy as a crime. Say, once you sleep with another man, you're committing a criminal offense. But with women, there is nothing. At the same time, sodomy doesn't prohibit dating, right? So we have loopholes to give a meaningful provision to that law. However, with these issues of human rights arising, because from a human rights approach, you don't say, that one is a violation of Section 56. You know what Section 56 is? It's about it's the equality grounds on the basis of sex. Simply saying, no, I need to be able to proclaim my sexual orientation. They would argue that. So their arguments, the issues like homosexuality, the issues like euthanasia, mercy killing, the issues like abortion, those three are still pending issues, whether or not they should be abolished, legalized. Many states or many jurisdictions have moved on to legalize most of them. But with these issues, there are always reasons for or against, depending on which side you stand.
But now let's bring the aspect of every child has a right to education. But now, suppose a 16-year-old and a 16-year-old girl and a boy, they're both indulged in sexual intercourse. The girl is pregnant. The schools or institutions, they expel the girl child. They're suspended from school, while the boy child continues to go to school. But now, every child has a right to education. The boy child and the girl child, How now do you say this one is pregnant, we can now expel them from school, but the boy child continues to go to school? How do you now reach that consensus?
If I'm to You know, look at the right to education. That's section 75. It's a provision. Once we say it's a right, we need to know what a right is. We are simply saying it's a legal entitlement, something that we are entitled to in terms of the what? Of the law. Something that cannot be taken away unless or where in situations where the law permits it to be, taken away or reduced, right? First of all, in your scenario, in the hypothesis that you gave, I think challenging the expulsion is the starting point. On what basis is a school, expelling someone? The question of whether I should expel a boy or girl, before we even get there, should anyone be expelled in the first place? Because by expelling someone, whether you want to expel them both or you want to expel the girl, you are already what? You are already violating their right to education. Whether someone is pregnant or not, it doesn't matter. What matters is they have a right to education. They need to go to school. To understand that ideally, there could be maybe in order to uphold that right, you can create measures. So say maybe when the time comes, they should be given a leave, a maternity leave to go and finish and still come back and continue with school. You can't be expelling them for what? To what effect? That's one thing. And then if we were to get to whether the issue of expelling a boy or not, right? Suppose they get away with expelling, then whether to expel a boy or not, already that's a violation of what? Section 81. The Children's Rights Bill, that one is very important because you are already treating them what? Differently. Something which the law does not permit. They should be treated equally. When they are both staying, they should both stay. If you are justified at expelling, then if you decide to expel them both. Because their liability is equal.
Right, Brian, as we close in terms of children's issues, children's rights, let's talk about the issue of let's bring the aspect of feminism into it. In terms of family setup, the way the boy child is raised and the way the girl child is raised is different. Even today, it's different. But now, how do you bring the aspect of children's rights into context there and try to educate the parents and society? These people are equal.
Now, I don't know whether the difference between the way of bringing a boy child and a girl child as a parent anymore. I can agree that it used to maybe back then when it's a rural setup, that as a boy child you have your own kind of responsibilities that you are supposed to face, and then as a girl child you have your own responsibilities that include you have to fetch water, you have to go for firewood, you have to do this 1, 2, 3. Then there are things that a boy should know. But here, most of us, I don't know, maybe in the rural setup it still happens, but most people, we are here, and that's where we embrace modern concept to say we should not be left behind. Right now, there is no problem with me washing the dishes. There is no problem with the chores are kind of like inclusive. So there is no way we can. What I'm entitled to is what the other girl child is entitled to. There is no way you can say, unlike a long time ago, where you can say, the boy child is the one who should go to school. The reasons given are 1, 2, 3. They are not going to go anywhere. They remain within the family. When you're gay, they are going to get married, and then you will go. So there is no use for us to educate you. All those are the differences in terms of treatment that way thing. But if you can look at them closer, you'll realize that those differences are outdated. Today, the girl child can learn as high as they can become professors, they can become whatever they want in an African setup. The same thing that a boy child can do, again, a girl child can do in terms of treatment. So that by maybe spreading that kind of awareness, if we are to try to reconcile our society to say, no, we need to carry out these, constitutional project. Is that it's just that the other thing that the society is, the problem that our society is. By society, I'm being all inclusive in terms of the age. I don't really refer to the adults only, inclusive, everyone involved. Is we fear things like the Constitution, for instance. The Constitution is not for lawyers and the courts, unlike many people think. The Constitution is for the people.
Yeah.
Right. That's why when you look at the preamble, the opening, this one is the preamble. Yeah. You see the opening. 15. You see the opening.
We the people
of Zimbabwe. That's what it means. The Constitution is not for the government, it's not for the ministers, it's not for lawyers, it's not for judges or whatsoever. It's for the people. Know your right, know what the Constitution. Because once people say document like this one is for lawyers, you understand. But if you are within the framework of saying, I'm interested in knowing the Constitution, we carry out projects of educating the people with their rights, guiding them, explaining to them. Because a constitution is not something that you can just read and understand. It's not a novel. You read it, but it has meanings and interpretations. You put a meaning to it, right? What it means. So if you carry out campaigns, probably educational awareness programs where you teach people about the Constitution, at least they are able to know I'm entitled. Because many people suffer not because they don't want to claim their rights, but because they don't know their rights.
Brian, thank you so much for coming to the show.
You're welcome.
Thank you for sharing more information on the children's issues. Right. This has been Know Your Right, and my name is Brighton, the B Factor. Till next time, know your right. We are the people of Zimbabwe. Know your constitution. #Asake. To follow us on Twitter at SideZW. To follow me on Twitter at Riddle Prefector. Till next time, #Asake.